Yes.
I beg to mention item number 7.
Huh.
The matter, this matter, release after 2 weeks for admission.
Okay. Item 7,
Yes.
after 2 weeks.
For admission.
Lordship, item number 8 to 11, Lordship. This is
Item 8.
8, 8, 9, 8, 9, 10.
Yes.
Yes, same method, Lordship.
Huh.
So, I have taken the permission from the opposite party, Lordship. This may be mentioned after 2 weeks, Lordship.
Okay. After 2 weeks.
Yes. And Lordship, item number 12 also.
8, 9, 10. After 2 weeks. Huh?
Yes. Lordship, item number 11 also.
11 also after 2 weeks.
Yes, yes.
Okay.
Lord, I would like to mention item number 3
Yes.
for adjournment.
Huh?
For adjournment,
Yes.
my senior counsel is suffering from some viral fever,
Yes.
so he couldn't make it today. So,
After?
yes, my lord.
You want it to be listed
Adjournment,
when?
yes.
When? When
But-
do you want this matter to be listed?
Actually, the matter it was motioned today, and after 2 weeks.
Okay, after 2 weeks.
Your Lordship, I beg to mention item number 14.
14.
Since
Yes.
Lordship, I was requested by the council for the respondent, Mr. S. Taye,
Uh,
to adjourn this matter since he is out of station.
when?
2 weeks
Okay, after 2 weeks.
of like.
Please, my lord. I
Yes,
beg to mention item number 5, my lord.
yes.
This may be taken up after 3 weeks, and I've taken the consent.
Okay, after 3 weeks.
Yeah, my lord, here, my lord, interim order is there, my lord.
All right.
It may be,
You are Mr.
Yes, Chetri.
S. Chetri for the respondent? Okay, the prayer of Mr. S. Chetri on the council for the respondent listed after 3 weeks. Interim order parcel shall continue till the next date of listing.
item.
Hmm?
Unlisted, very well for unlisted. Tomorrow is 15 of August.
Will be able to take up today?
Proceeded, he is able to take up today, then also,
Huh?
they will take up.
What?
It can be taken up also today.
What bail application?
To bail, anticipatory bail application,
Anticipatory, what is the section?
295.
What is 295?
Lordship, with hurting religious sentiment.
Religious sentiment.
Yes, there has been a dispute, civil dispute, Lordship. However, the FIR has been filed under 295. Registered under 216.
We'll do it on 16.
Lordship.
Huh.
Number 1.
By way of this revision petition, I'm challenging the order dated 12 July 2023, passed by 11th Second Court of whereby, although as per the investigation report of charge sheet matter, there's ample material, sufficient material for charging under 302, and also the charge sheet has been charging under 302.
Has been discharged.
Not discharge matter. Now it has been wrongly framed the charge under section 306, where there's no element of 306 matter, abetment to society. It's a case of 302, but instead of framing charge under 302, 306 has been framed.
What is 306?
306 abetment to society. There's no element of abetment to society. But the court has speculated without material on the record. That is the case of 306. I'll just come to the my lord, the brief fact, my lord. I'll just highlight the brief fact. My lord, the fact of the case is, my lord, on 12 January 2021, my lord, the seized person was found, my lord, critical condition, having sustained multiple bullet injuries on his head at his private residence, my lord.
Yes.
And that gun was recovered from the outside house.
What was recovered from outside house?
Yes, outside that place of occurrence, it was found outside the house.
Dead
After the
body.
incident.
What was found outside the?
Gun.
Oh, gun.
Which was involved in the incident.
Yes.
Now, what happened at that relevant point of time, the accused man, that is respondent number 2, he was the only one, law person who was present along with the deceased person at the place of occurrence. Therefore, having seen these the suspicious conduct and nature, the FIR was lodged on dated 14 January 2021, at Basar PS against the respondent number 2, at page 22, against which initially Basar PS case number 02/2021 was registered under 306 initially, page 22, Now, thereafter, this
Ag-
case
Against whom?
against respondent number 2, that is the wife of the deceased. Now, subsequently, after registration of case, this case was transferred to the crime branch SIT Itanagar for investigation, as the case appears to be a premeditated murder case. So, accordingly, after detailed investigation carried out by the crime branch SIT, charge sheet was filed on 11 March 2022, under section 302 against the respondent number 2. Now, the incriminating material that has been collected during the investigation, I'll just take to the charge sheet. It starts from page 27. And just relevant material that I'll take to the page 32.
Yes.
Yes. Now, page 32, we'll see serial number 2, Roman serial number 2. Diary of the accused person was collected, was seized during the course of investigation. And in that diary, will see the incident occurred on 12 January 2021, and the entry that the diary, personal diary of this accused person seized during the investigation. Now it is written that written as on dated 11 January 2021. That is prior to the incident that Park Jung died. This is person died. Now, this is it is premeditated already. This plan was plotted. It was premeditated because prior to the incident, how can they written that is a died? It was written by. And this handwriting, it was examined by the forensic expert. Now it is found that it is no any tampering has been. It's the original handwritten of the accused.
Disease were killed by the gun. Disease was killed by the gun.
Yes, yes.
Whose gun was it?
Gun belongs to the deceased.
Disease.
Yes.
Then
Now thereafter, again, serial.
what is the material? What is the material to link with the respondent number 2, the wife?
Now, respondent number 2. Why I'm linking? Respondent number 2. Now, the right from the incident, there was their relation, matrimonial relation was extremely. It was not going well.
That's all right. How do you connect with her with the act?
Yes. Now,
Act of killing her husband.
yes. Now, so far the killing, that part, from subsequent conduct, and also the accused person, has sustained during the investigation, it was found that she has sustained injury on her hands. And it was examined, medically examined. Subsequent conduct of detail, it's clear, it's established that there cannot be the other person other than this deceased person.
How?
The accused person.
How?
After the incident, now the incident, at the time of incident, she was the only one who was with the deceased person. Now, near within the outside the room, my lord, the maid servant was there. The maid servant, my lord, on the call on the calling call made by the accused, my lord. He ran into and he showed that, my lord, deceased was in a critical condition, patting his head down, and there was no gun nearby the room, my lord. And it was the statement of the accused that she shot he himself has shot the fire, shot the fire.
Whose statement?
Statement of the accused. That the respondent. Now it is her version. Now what happened? That the injury sustained, my lord, but the deceased person gets multiple injury. It was repeatedly it was fired. If it is the case of the suicide, that cannot be repeated firing, cannot be possible. And even if it's there, then why this?
The statement that she killed the disease
Yes,
was made when and before whom?
my lord, it was the hard statement only,
Which,
and it was made before the my lord, the maid servant. The first information at the time of organized matter, immediately under same room, my lord, the deceased and accused was there, and outside the maid servant was there, and it was just narrated to the maid servant, my lord, that this thing happened. But later on, my lord, on investigation, the gun was found outside the house. How that can be possible? Now, second, my lord, after the incident, my lord,
is there a provision for alteration of a charge during the course of a trial?
my lord, there's no alteration. It cannot be. This only trial had been.
No. See, charge has been framed, 306. If during the course of a trial, if it appears to the court that no 302 is attracted, is there a provision to alter the charge?
If I may, to that question, Your Lordship.
Yes,
If it so happens only while framing of the charge, Your Lordship. Secondly, prior to pronouncement of any judgment, Your Lordship, under 222, such alteration can be done. However, 222 clearly says that the charges that has been later on changed, Your Lordship, the punishment should be minimum to what the actual charge has been
Framed.
under what actual charge has been framed. Your
mhm.
Under 222, Your Lordship, it says that the court prior to pronouncement of the judgment, they can alter the charge. However, the charge should be, the altered charge should be, punishment should be less than
222 is what? what is that?
CRP 3, Your Lordship.
No, what is that?
Alteration.
Alteration of charge.
Yes.
222.
Yes.
Yes,
My lord,
when offense proved included in offense charge.
Yes, Your Lordship. If I may read, Your Lordship.
Yes,
When a person is charged with an offense consisting of several particulars, a combination of some only of which constitute a complete minor charge, and such combination is proved, but the remaining particulars are not proved, he may be convicted of the offense, minor offense, though he was not charged with it, Your Lordship. It has to be a combination of the major offense.
my lord,
what is 216? What is section 216?
My lord, this is, of course, court may alter the charge. Now, here, my lord,
No, no, what is 216?
216, my lord. Court may alter the charge. And any court may alter or add any charge, my lord, at any time before judgment is pronounced. My lord, here, my lord, now this is, the charge has already been framed under 206, 306. Now, when there's no material of 306, even if during the trial, my lord, if if it's charged to be altered, it will ultimately not prolong the matter.
You are challenging the framing of a charge.
Yes, ma'am.
Is there no any alternative remedy provided under the CRPC? Is the only option left with the petitioner is to challenge the charge frame?
My lord. My lord, in such, my lord, serious matter, my lord, because the trial, my lord, even the trial, my lord, suppose in the, as per 206, 201, 216, if in the letter force, my lord, original charge is to be that ultimately, my lord, that is the after the, my lord, trial is almost after examining the evidence. So that will again, if it is altered, again, retrial has to be taken place, giving the accused opportunity.
Hmm?
This will, madam, prolong the matter, madam. So what my humble submission, madam? If the, as per charge sheet, if it is framed, madam, this can be at a type of.
No,
judgment,
you had mentioned some stage of alteration of the charge.
Madam,
Which stage?
madam, it says that madam, alteration or addition of charge is such that the proceeding immediately with trial is not likely. I'll just read that this 216. Any court may alter or add any charge at any time before judgment is pronounced. Before such alteration or addition is read and explained to the accused. If the alteration or addition to the charge is such that proceeding immediately with trial is not likely, in the opinion of the court, to prejudice the accused in his defense or the prosecutor in the conduct of the case, the court may, in his discretion, after such alteration or addition has been made, proceed with the trial as if the altered or added charge had been the charge.
What does it mean?
With,
Subsection 3, what does it mean? What have you understood from subsection 3?
Madam, again, 4, madam, subsection 4, madam. If the alteration.
No, before proceeding to 4, let us understand 3.
Madam.
What is 3?
Madam. It is the opinion of the court. It is not likely to prejudice that accused. Then it may alter. Brother.
Yes.
Well, in my submission, if it is the opinion of the court that it's not prejudicing the accused, then they alter the original charge. But but in case, in case if it is feel that it's likely to prejudice, then it has to be started new. Trial has to be started.
Yes, PP, APP, what is 216?
216, your lordship, if I may, your lordship, this 216, the court can invoke under 216 after the witnesses are being examined. Lordship will see directly the next provision 217, recall of witnesses when charge altered. Now,
216 is controlled by 217.
no. What I'm trying to, the process, your lordship. Now, their case is that immediately, now their, the charge had
So
been framed.
you forget about 217. 217 we will understand tomorrow.
Yes,
Today, let us understand 216. What is 216?
your lordship, after the evidences, depositions of the witnesses are being
Where
made.
is, from where do you read evidence have, are deposed, something like that?
Yes, therefore I was reading 217, your lordship. It's interconnected, your lordship. Your lordship will see when a charge is altered or added to by the court after commencement of the trial.
See, just a moment. When will the court alter the charge under 216?
Yes,
It is only after alteration of the charge,
yes,
217 will come into play.
yes.
You are reading 217 first and then you will read 217.
No, your lordship.
See, recall of witness when charge altered.
Yes, your lordship. Now,
We are not interested in recalling of the witness and what the witness has to, what the witnesses has to be done
yes,
after the charge is altered. We're not interested in that. We are interested to know what is this court may alter the charge about,
yes, your lordship.
which the legislature has engrafted under section 216.
Yes, your lordship. Now, your lordship will see 216, it can be invoked at any point of time before judgment. First is framing of charge, your lordship. After framing of charge, the witnesses are being called for their depositions, your lordship. After their depositions are being taken and the court comes to a view
Where,
that
where do you say depositions?
will,
In 216.
yes, your lordship. Your lordship will see after framing of charge, it's purely on the basis of the charge sheet being filed, your lordship.
Hmm.
Now, after framing, after the charge sheet is being filed, all the evidences in the charge sheet, your lordship, thereafter the charges are being filed, taking into consideration the charge sheet, your lordship. After the charges are being framed, your lordship, how will a court alter the charges? When a court finds the prima facie, there are another charges or so-called the charges framed during framing of the charge, your lordship, it needs to be altered. How will that be, your lordship? After the framing of charge, whatever evidence comes to the court's notice, that is, be it depositions, your lordship, of the witnesses, your lordship.
Both of you are not prepared on 216.
My lord,
Huh?
even, my lord, my humble submission.
See, one has to be honest.
Yes,
If you're not prepared, we'll take it up some other day. You also look into what is 216?
My lord, 216, my lord, my understanding, my lord. Of course, before the judgment, that alteration can be done as per 216. But now, if it is prejudice, obviously, my lord, the section that I'm praying for is 202, my lord, 302, my lord. It is more grievous than the 306.
Okay, just what is 216 clause 3? Very pointed question. Forget 1, 2, 4, 5. What is 3?
Yes, if I may, lordship, once 216 is the court
In a simple,
provoked 216.
in
your
a
lordship.
simple language, if you have understood.
Yes, your lordship. If 216 is invoked by a court, your lordship, a notice has to be given to the accused or complainant. Your
Just,
lordship. A notice to the accused or the complainant may be given, your lordship. That certain charges being informing the complainant or the accused, your lordship. Now, clause 3, your lordship, if the alteration or addition to a charge is such that proceeding immediately with the trial is not likely, in the opinion of the court, to prejudice the accused in his defense of the prosecutor in the conduct of the case, the court may in its discretion after
You will have to know.
In my understanding, my lord, clause 3, my lord, if it is the opinion, my lord, of the court, my lord, trial court, that if the alteration, even if it's made, my lord, it is not likely to prejudice either to the accused or the prosecutor, my lord. In that case, it can be altered, my lord. But if it is of the opinion that such alterations are likely to prejudice the accused or the prosecutor, then court may direct new trial or adjourn the trial for such period as may be necessary. Madam, this is directly prolong the proceeding. When at initial stage itself, my lord, at the framing of CC, my lord, it is well clear established that it's the case of 302, my lord. There's ample material. Then my humble assumption, the directing and charging, framing the charge under 306, it is, my lord, is not enabled. Had there been no material evidence, then that would be a different thing. When there's a clear case, clear evidence.
Both of you agree that court has the power to alter the charge.
Yes.
Alter the charge means court can frame a new charge also.
Yes.
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 If that is the position, should you not move an application before the trial court under this provision?
My lord, before
Because what will happen here is, what can be done in your case? Two courts open. One is notice. Is not it? Notice means then we will adjudicate the matter. Trial will continue. And ultimately there will be some result, some decision here. Now, you are praying for stay also.
my lord, I pray for
Then there is the next course also. Notice and stay. Then trial will not proceed. And at the end of it, some decision will come. So at the end of the hearing, we might find out that you have to approach the
Trial court.
trial court. Then what happens? You will be wasting your time
My lord. That is, my lord.
because what I have found out from reading of this commentary is subsection 1 and 2 of section 216 are comprehensive, including not only correction of an error in framing the charge, but also non-framing of a charge. So the initial query, is there any provision in the CRPC to alter the charge? Was to find out if there are other remedies available. This is 482.
My lord, no, not for it.
Revision.
Revision.
Revision is also, see, revision and 482 is also revision.
My lord, that is inherent part, because since there's, I personally, my lord,
Ah.
this part of the material report.
Inherent power is the last resort.
My lord.
That is very restricted. And revision is also on error of law, is not it?
Yes, correctness of the.
So that is file when there are no remedies available. Even if there is an appeal, you don't file revision, isn't it? So if there are provisions in the CRPC itself, why should you resort to revision? That it was for that purpose this query started. What to do? Notice or you'll examine? Or notice or stay also? Both is not to your advantage.
My lord,
At least you will be prosecuted under 306. What is the punishment?
punishment, my lord, this 10 months, maximum 10 years.
10 years. You want you don't want 10 years only. Beyond that.
Yes,
But in the process, if you don't come clear on this, everything will be put on hold. Notice or you will examine.
my lord. Short notice, my lord, will.
What sort of notice?
my lord will examine it.
That notice means notice. Will issue notice. Then other side will appear. That accused will appear. Accused might raise this issue as point.
My lord.
No, the petitioner ought to have approached the trial court itself. There is a provision on 216. Then also you will have to answer the questions which the court has posed now.
Yes.
So both of you can't run away from 216.
Yes, Your Lordship.
My lord, in that case, my lord,
Yes. What in that case?
my lord, will take time, my lord,
Okay, after a week, on
Madam.
the prayer of Sri Targum, after a week. Yes.
The case arising out of the. It's another case. P76. Application on section 4 that is going for the pre-arrest.
Hmm.
illegal encroachment of government land and constructions are disturbing the public order and tranquility. And whereas it is felt that there is a need for restriction of all types of encroachment and construction of any structure in the aforementioned area and evict any structure within the enclosed area within 7 days. 7 days. And therefore, in the greater interest to maintain public order, I see so-and-so district magistrate, East Siang District, Pasigat, in exercise of the power conferred upon me under section 133 CRPC, do hereby prohibit all types of construction and to evict any structure erected in the aforementioned area. Since the nature of the order is urgent, the order is being passed ex parte and will come into force with immediate effect until further order. So there are so many people out there, not a single has been given by name. So it's a common order. Even I have not received any order, but some parts of my boundary fencing has been removed, and some parts of brick fencing which I was under construction, that is there, and the pillars have been brought down, but that has not been cut. That has not been touched. So then again, you receive it's next page is page 18, next to 2. This is the order. Pasigat, the 1st June 2023. In pursuance of the district magistrate, executive order number so-and-so, dated Pasigat the 15 March 2023, and on subsequent ground reported from the DLRNS office by his report number so-and-so of dated Pasigat the 22nd May 2023. The following magistrates are hereby directed to perform magistrate duty for eviction of illegal structures on the allotted plot for Department of Civil Defense Training Institute at Govind Nagar, Pasigat on 6 June 2023 at 11 a.m. So, as per this order, some of my fencing that was barbed wire fencing and the iron gate has already been dismantled, except for the brick wall, which I was trying to do it in the permanent measure, and RCC pillar was under erection. So that I have annexed in the my petition. Now, next is page 20, here annex 3. Here, if I have request for regularization of my land at Govind Nagar, Pasigat. So here, serial number 1, I'm reading from middle, that on being acquired the land from a private individual in the year 2002 and is in continuous possession of the land for last more than 22 years without any objection from any corner. I have right over the land and its title. 2, that the authorities ought to have issued notice to me before eviction of my structures. That the allotment to the Department of Civil Defense Training Institute was done over and above my land on 27 March 2015. That too, by relocation of their earlier land allotment. The authorities should have issued an order for claims and objections. There are many other occupants in the same area, but have not been evicted. That in the same area, many private individuals occupied land have been regularized by giving allotment by the government, but the application for regularization submitted by the applicant have been kept in abeyance. that the application has obtained no objection certificate from the departments like Town Planner, District Disaster Management Office, Range Forest Office, Divisional Forest Office, Executive Engineer, UD and Housing. That the application for regularization allotment of my land is pending disposal before the DLRS and SO of your office. That by memo number so and so, dated 24th May 2012, the Commissioner Land Management, Government of Arunachal Pradesh, issued a memorandum for regularization of occupied land by individuals. The order copy was issued to all deputy commissioners and all LRSO for necessary actions. Thus, the land of the applicant could have been regularized by that order. Natural justice demands that an official notice should have been issued to me before an action for eviction was taken up. So personal hearing is needed. In the above backdrops, it is therefore to request your benign office that the land in question is allotted to me for the ends of justice. It is also requested that your office would be pleased to issue an order directing the other parties to stop construction works, if any, in my acquired land until disposal of this application with the speaking order. So this also they have not done. But every second day they come and talk of dismantling of my area. So
How many encroachers are there?
I have mentioned that almost 60. I have made a statement. Paragraph 14, page 12, that the petitioner begs to submit that as per his knowledge, there are 28 persons having land in the same locality. Some of them have been allotted their occupied lands.
No. How many encroachers are there?
Lordship,
Those who have allotment are not, we are not concerned.
Lord, encroachers as such, they have not given my name also.
No, that's what I'm asking. See, you can't be aggrieved of this order, which order is not directed against you.
But they have, Lordship, as I have stated.
You
in the
see,
pre-
any order we pass in your favor, those who have encroached the land will also take the advantage. It is in that context. The question is, how many encroachers are there?
Lordship, so far encroacher concerned, records is for the office. So far I am concerned, I have given some of them in my rough sketch map.
So what is your relief?
Lordship, there is a similar order. I have annexed in the last,
Where?
yes, page 46. Page 46, Annex 7. It was passed on 14/6/2023. Same Lordship, place and same order, everything is same. And to the extent that petitioners also copied. This honorable court has passed two orders in two different petitions. So I prefer the same order, Lordship.
I am afraid I will not be able to pass such order. See, here
Lordship.
blanket is there as far as this person is concerned. That is what I am saying.
Lordship,
Who was the petitioner there? Anong Tamut.
Anong Tamut.
As far as Anong Tamut is concerned, blanket stay. It is made clear that no further demolition shall be carried out pursuant to the order that is so and so. Correct?
Lordship.
You are asking the same benefit. I was not aware of this. See, now this is the beginning.
Lordship.
That court had granted this kind of interim order. Now you are coming. Now it will be lined up. That is why the court is asking, how many encroachers are there?
That records I do not have, but
See,
I had
there
read
is,
it.
just a moment, there is one more. At page 49. Okay, both of them had come on the same day.
Yes.
Now today you have come. Tomorrow there will be a series of,
Lordship may be pleased to see page 45.
yes.
This is my area. I
45.
have made a sketch map.
No, but see, this notification is not directed against you. If anything is done on the basis of this notification, you may take, you may avail of other remedies available to you.
Lordship, prevention is better than cure, Lordship.
No, see,
Now, Lordship, I have, in my photographs, I have shown that the obligations so far Salan is also concerned, we have deposited. And Lordship, here, Lordship.
let us see the status of your land. If you don't have any, it appears to be an urban area. According to them, it is allotted to,
Lordship, may I furnish the colored
no,
photographs?
that can't be. This is, but you are challenging this. This is again a criminal petition.
Yes, Lordship. Because it's under 133 CRPC, Lordship. That title of the land, that is altogether different chapter, Lordship. That will fight it out. But so far this 132 is concerned, he has violated all the norms and practice. That is what. I am not seeking permanency of that law land in my favor from this honorable court. I am saying that eviction done was illegal and other rest which has not been done also will be illegal,
Was your occupation legal?
Lordship.
Was your occupation of the land legal?
Lordship.
This is a disputed question of fact.
Lordship.
See,
Pasigat.
You should file a suit accompanied with the injunction.
No, that Lordship obviously will have to be. But
You should have done moment this order was issued.
this order was not personally given to me till then, Lordship.
So how you are agreeing? Okay, let her take instruction.
Lordship.
Okay.
Lordship, moreover, Lordship, this earlier order which they have granted this stay order, Lordship, that is, Lordship, that order was passed on 14/6/2023. And this order was, Lordship, this last page, Lordship, it is made clear no further demolition shall be carried out pursuant to the order dated this the returnable date, Lordship. A returnable date already, Lordship, expired after 3 weeks, Lordship. It's June now, this is August, Lordship. So, Lordship, maybe, Lordship, now what present status is now, Lordship. So maybe the request may be called for, Lordship.
Then what happened?
That's why, Lordship.
What
Now-
happened? What happened to this case?
Lordship, that's why, Lordship, this is the, maybe this case is, the what stage, I have no idea, Lordship, because order only I have seen, Lordship. This order was passed, Lordship. But this order was, they have granted the interim, Lordship, that is for the return, till the returnable date only.
So according to you, when the returnable date expired?
Lordship, from 14/6/2023 to after 3 weeks, Lordship. So 3 weeks to Lordship, July, it's been expired Lordship.
July expired.
Lordship. Now it's,
Then what happened to this case?
Lordship, that's why Lordship, I have to seek the instruction Lordship.
If you don't have any instruction, then what can we do? You have to know all this.
Lordship, today only, this is motion state Lordship. Now today only I have got through that, this, petition Lordship. So that's why Lordship today, no, maybe.
Have you filed for vacation of this interim order?
Lordship, earlier Lordship, I was not appeared in this matter Lordship. And they, when this
See,
order was,
how we are concerned, who appears?
Lordship,
You are APP.
Lordship,
For us, APP and PP is the same.
Lordship, but Lordship, this other APPs also there who have appeared. Yeah, PP was appeared Lordship. His name,
For us, government is government.
Lordship.
We can't say that Lakshmi government, Pangu government.
Lordship, there's a Lordship, notice maybe is the end point for the instruction. Lordship.
And the query is, see, this petition is relying on this order.
Lordship.
Have you filed application for vacation of this order?
Lordship, I have to no idea Lordship because
It is very dangerous order.
that's why Lordship.
Huh?
I have gone through this order just now Lordship. And because the Lordship and this Lordship applicant also Lordship and
What?
petitioner, they
But what I had stated just now, that okay, if there are not many encroachers, it is all right, he may be the last one. But if there are another 50 encroachers, they will come with a series of applications.
Lordship, and Lordship may go, may see Lordship, this, youngster tree also Lordship, after this order Lordship, they have, request for the regulation of the plot Lordship, this is 4/7/2023 Lordship.
That we cannot go into, this is criminal revision, no, criminal petition. Huh? Deputy Commissioner is not a party here. All right. So arguments on the part of the PP may be available also, this is not maintainable. How he is affected by this order. I don't know whether you will raise this or not.
Lordship, that's why Lordship, which is ordered Lordship, it is, Lordship rightly pointed out, yes, his name is not there Lordship. It is Lordship kind of blanket order Lordship, so Lordship, if he's agreed, then Lordship, he can approach that concerned Lordship magistrate also.
What is this 1996 7 SCC 71? CA Amarachan versus CV Srinivasan.
That is, they relied by the petitioner Lordship. They relied by the petitioner Lordship.
It's a
Petitioner.
very short.
What is that case? What is the law laid down in that case?
Lordship, it's just 2 pages only. If I'm permitted, I'll read it over.
Yes.
Civil Procedure Code 1973, Section 133 and 138. Non-compliance with the mandatory requirements of drawing up a preliminary order before proceeding under Section 133 affect health vitiates the entire proceedings. Now, leave from order, leave granted. Respondent 1, along with another person, file a petition under Section 133 of Code of Civil Procedure Code against the applicant, alleging that he blasting the rocks in an area on a large scale, thereby causing nuisance to the respondents and others. The petition was filed on 21/1/1986. The subdivisional magistrate summoned the appellant to appear before him by an order dated 27/2/1986. Since the subdivisional magistrate proceeded with the inquiry without drawing up a preliminary order, the appellant approached the High Court challenging the proceedings initiated by learned SDM without drawing up a preliminary order. It was directed by the High Court that the objection raised by the appellant be considered and disposed by the subdivisional magistrate. It, however, appears that in spite of observations of the High Court, the subdivisional magistrate did not draw a preliminary order and proceed with the inquiry in the case. During the pendency of the proceedings, a commissioner came to be appointed by the consent of the parties to submit a fact-finding report on 11/11/1987. When the matter came up before the subdivisional magistrate, neither counsel for the appellant nor the counsel for the respondents were present. Even the objections to the report had not been filed. We do not know the reason for absence of the counsel for the parties on that date, and as the record is silent. However, we find that the subdivisional magistrate, after perusing the report of the commissioner, held that the appellant was causing nuisance from the quarry industry and directed the quarrying and blasting operations should be stopped permanently. A direction was issued to permanently close the quarry operations. The matter was taken to High Court by the appellant, which noticed that preliminary order that had not been drawn up and even final order had not been drawn up in the prescribed form, but held that those defects were mere irregularities and did not affect the validity of the proceedings. The order of the subdivisional magistrate was upheld. In our opinion, the omission on the part of the subdivisional magistrate to draw up preliminary order, which is a sine qua non for initiating proceedings under section 133 of the Code of Civil Procedure, and without following the procedure provided for section 138 CRPC, the order made by the subdivisional magistrate on 13/1/1988 it is unsustainable and is vitiated. The High Court fell in error in not properly appreciating the effect of non-compliance with the mandatory requirements of drawing up a preliminary order before proceedings under section 133 CRPC. Neither the order of the High Court nor that of the subdivisional magistrate can therefore be sustained. This appeal is consequently succeed and is allowed. The order of the subdivisional magistrate dated so-and-so and of the High Court dated so-and-so are hereby set aside. So procedures are not taken up. Just the order was issued and directly evicted my private work fencing, except for that permanent
See,
wall.
what is your submission on merit? Merit of the case.
Lordship, Lordship, here, Lordship, as the order was passed 133, Lordship, and his name is not there, Lordship. There's a blanket order regarding all the occupant, eviction who we have done forcefully occupied, Lordship. That is order for all of them, Lordship. So, Lordship, instead of Lordship praying for the quashing, Lordship, his name is not reflected, Lordship, so that he can approach before the Lordship magistrate, Lordship, so that Lordship he can approach the Lordship, so that the Lordship here, Lordship 133 is a conditional order for removal of nuisance, Lordship. Here, Lordship, magistrate may make, Lordship, conditional order requiring the person causing such obstruction, nuisance, or carrying on such threat or occupation, or keeping any such goods or merchandise or using possession, controlling such building, tent, structure, substance, tank, well, or exhibition, wing, or possessing such animal tree or within time to fix in the order to remove such obstruction, nuisance, Lordship. If he objects to do affair before himself or some other executive magistrate subordinate to him at the time and place to fix by the order, so goes to the manner herein after provided why the order should not be made absolute. So, Lordship, if he is aggrieved, Lordship, with this order, Lordship, so he could approach this, Lordship, before the magistrate, Lordship, because this order, as per this 133 order, the magistrate is clearly, Lordship, stated that it is the, Lordship, Lordship, this is, Lordship, which felt that there is a need for restriction of all type of encouragement of prices in the associated area, if any such being the exclusion within 7 days, and therefore, because this is time urgency, Lordship, in the urgency of this Lordship situation, this order has been passed, Lordship. As this 133 CRPC, what the magistrate order is, Lordship, is reflected. Here, the Lordship may go to the order, Lordship. The report has been received from the source that some unknown person unknown person, Lordship. The name is not there, Lordship. Only unknown person has illegally encroached the allotted plot of Department of Civil Defense Training Institute at the agreement number Pasighat. Lordship, these are Department of Civil Defense. This is, Lordship, the where the training institute is there, Lordship. So maybe, Lordship, there is this encroachment was done, Lordship. This is illegally, Lordship. So, Lordship, maybe, Lordship, this complaint was been made, Lordship, by the source, Lordship, that the various person may be there, Lordship. But whether this name was there, Lordship, it should be looked into, Lordship. So he should approach before the Lordship, appropriate form, Lordship. Because, Lordship, when this order is received from here, it will again the other party will come, Lordship, as the Lordship has rightly pointed out.
Had my name would have been there, the approach before the honorable court would have been different with another sections. But I have made a environment. I'm sorry, Lordship, there at page 3, I was supposed to make some correction, but I did not do it. I have just forgotten that the petitioner begs to state para 3, Lordship, that the petitioner was not inserted, Lordship, that the petitioner begs to state that the learned district magistrate did not serve the interim order.
Just,
that-
no, we have understood.
Lordship. So,
See, you appears to be encroacher.
yes, by this time,
Hmm?
by this time.
By this time, means?
Otherwise, Lordship, that's why, Lordship, if we go for title suit, then, Lordship, it will come. When I purchase that land and from whom I have stated 20 years, Pasighat Municipal Corporation, Eternal Municipal Corporation was established on same day. Now they, and then the allotment, Lordship, to the civil wing was given in 2014, Lordship. So over and above my land, they have given allotment to civil wing. Now, without hearing me, in 2014 itself, if I would have been directed, and if government would have claimed that this is government land, why have you encroached? Then my construction wouldn't have been there. Then this, and Lordship, I have shown the NOCs from all the departments. Urban Development Department has given NOC, Forest Department has given NOC.
That way, see, that way, Mr. Afan.
Lordship, even if they are going to take back, at least give back some compensation to me. I deserve that at least.
It is not like this. We have to think of a wider ramifications it will
Yes,
have.
yes, Lordship.
If your contention is accepted, it will be, once we pass an order in your favor, we'll have to pass order to the similarly situated person.
That's why, Lordship, I'm on this 2 writ petitions.
That I'll distinguish.
Now,
I am wondering why they have not, wondering why they have not come for modification of this order.
other way around, they
On strictly merit, I will held that this criminal petition is not maintainable. See, it is like this.
Lordship.
There appears to be no dispute that you, along with these 2 petitioners and many others,
Many others.
are encroachers. Now, this authority, what they have done, they've invoked the wrong provision in the wrong manner. They could have proceeded against you under Public Promises Act. Now they picked up this 133. So because of that, you are getting some points to us, legal points to us. But it appears you yourself says you are an encroacher. So you are not the only one. There are others also. See, from your petition itself, even if you don't admit, it will look like your barbed wire and fencing and that iron gate was evicted or dismantled on 6th June
Lordship.
2023.
Lordship.
You did not do anything. Neither you came before this court, Then after a month, nearly a month, 4/7/2023, you submitted on representation to the deputy commissioner.
Lordship, we did not get even this order. We have got this order, the impugned order, after filing of this repetition, Lordship.
But your friend,
Government is supposed to be, Lordship,
but your friend got it before 14/6/2023.
for
That earlier writ petition, 102. Order was passed on 14 June 2023. That means that petitioner, Anong Tamut, got this order before 14/6/2023.
they knew it. They knew it, Lordship. From them only, I came to know that my fencing has been evicted. That's why, Lordship, on 4/7/2016, I am writing representation to the deputy commissioner.
What to do? Will issue notice or let her
Or else, Lordship,
bring instruction?
after all, Lordship, the title of the land will not be conferred from this honorable court. So we are only against this 133.
Okay.
Now, this may be, Lordship,
All right,
I may be heard,
all right.
and the petition also can be disposed of, Lordship. Until I am heard,
We will then say that this impugned order shall not be applicable to you,
in respect of me.
but authorities will be at liberty to proceed against you under Public Promises Act.
That law may not be cited. As per rules available to them, as per any proceedings available to them, they may not be made, Lordship, wiser. As per law, Lordship,
No, see, legally speaking,
the Public Premises, Lordship,
see,
Public Premises Act.
we at this stage, we don't know what you are saying may be correct, but I think it is only if the order issued under 133 is directed against the person, then that person can only challenge this. This is in general.
Lordship.
We don't know whether it is directed against you or not.
That's why, Lordship. Even I do not know, because till that I have not been
You
served with
see,
this.
you see, this-
But
Con-
effect, Lordship, that eviction has been done. That is the effect. That is not
You-
everybody, Lordship.
you file a suit for damages.
Again, Lordship, whether you had a title or not, if you don't have a title, then there are no damage.
This is the law. What can we do?
No.
See, writ court is not for everything. See,
Lordship, now,
writ court is primarily for violation of a fundamental right. If your fundamental right is violated, court has no option. It is the constitutional duty of the court to protect you. Right?
Yes.
Court has no option. Second, legal rights. Then also court will protect you. Third, for any other purpose. Huh? In this any other purpose, you have to satisfy the court that some injustice has been done to you.
Lordship, that's why, Lord.
No, that is not injustice, Mr. See, that is not injustice. You are an encroacher. How can there be an injustice?
Lordship, in same area, that they say that is government land. I have made an averment saying that many of them have been given allotment in the same area. That
And-
averment I
and-
have made, Lordship.
Oh, sorry,
So
sorry.
that is injustice to me.
Just a moment. We are discussing as if we are sitting on 226. This is what?
Right.
Just a moment, just a minute. This is 482.
Okay.
Revision petition.
Criminal petition.
Criminal petition. For what purpose? Is there any other remedy for challenging this? Order passed under 133?
For revision, they could lawsuit, but 482 is the lawsuit, inherent power of this court lawsuit.
I think the revision lies before the sessions court.
Lawsuit.
To this court also.
Lordship, High Court 401, Lordship, it's not. Because it says appropriate Lordship court is Lordship, yes, the Lordship.
Huh?
Appropriate court is Lordship, dear Lordship.
Lordship may issue notice and short time may be given so that they will come with instructions.
Reading of 133 is, looks like, if you allege that the provision of 133 has not been followed before issuing that, only the person against whom the order is directed can approach this court. All these are there. These are very, see,
That's well, Lordship.
Mr. Lordship, I have, in the.
At least
Lordship,
names.
you have argued so, but not that specifically.
Lordship, I pointed out
See,
this.
initially you said it is a motion stage. It is at the motion stage where you have to object, You know that. Otherwise, see, stay order will be for asking. You see these two repetitions, no repetition, two criminal petitions, no further demolition. You say you are now taking the shelter till returnable debt. And you have no idea. We'll issue notice, returnable 2 weeks. Yeah. Well, and you find out. These are the orders you have to defend if you feel for the state. And you should have immediately filed an application for vacation of those orders. Whoever. It's not that you did not appear.
And Lordship, no further action on the notice.
That I can't. If you want, if you press for that, I'll have to pass an order rejecting that, and even I'll distinguish this order, which you have relied on.
Lordship, rightly
And otherwise, and let 2 weeks pass. What instruction comes depending on that. I'm expressing you very frankly, this order is very dangerous order. And on merit also, I can distinguish it. I can even reject the petition as not maintainable. But this is I'm not doing because something is happening there. You may be encroached, they are also not acting in accordance with law. So let some instruction come, whatever is there. But strictly on merit, it may not be maintainable. It is 133 is order for removal of a nuisance. Nuisance can be of any form,
Yes,
construction or whatever it is.
yes, Lordship.
Now that order has to be directed against some person who is constructing such activities
Lordship.
and thereby nuisance. And that person can challenge that no, this evidence was not taken, those procedures were not taken. This is not directed against you. So I don't think anybody can challenge this.
That's well,
They
Lordship.
have come or merely on the apprehension,
That
Lordship.
that is the
No,
dangerous.
no,
thing,
not
Lordship.
necessarily. You may have, this may have done something else. But if they have done anything on the basis of this order,
Lordship.
they will be responsible.
Yes, Lordship. Hope she will convey the message. Lordship.
Notice, 2 weeks,
Lordship.
yes.
With the words of Lordship, that last word,
Hmm.
they will be responsible if anything.
No,
is done.
see, things are not in order. Wrong from your side also, wrong from their side also. But then we can't be swayed away by, our orders can't be in that line. The actions from this side and actions from the, if they're not, our order has to be on the basis of This is not something like this.
Okay.
All right.
By last order, CD was called for one. And in the meantime,
Oh.
I was issued a notice under section 41A of CRPC. Accordingly, I have here and my statement was recorded.
Interim.
No, there was no injury.
Oh, you went to police.
No, a notice under section
Oh, I see.
41A.
Okay. They did not arrest you.
Yes.
I have the case there, Your Lordship. I've received the
Yes,
case there.
yes, they.
Yes, Your Lordship.
So
What is the
when
FIR?
section 41 was issued, I appeared. Now I am more apprehending. Since I knows the AV is pending.
His statement has been recorded, Your Lordship.
Okay.
And he
What is
has,
the FIR?
Phase
15.
11 to 15, yes, 15. Ma'am. And it was registered on 22nd July 2023. It's a letter written to the SP. Then this letter has been treated as a FIR.
Just a moment. What is the FIR? Phase 15.
15, my lord.
Okay. Okay. FIR is by Pankaj Kumar,
Yes, ma'am.
director.
Yes.
Where is your name?
My name is not there, my lord. I am the proprietor of this,
D. Raju.
yes, ma'am, MS. All the section involved in this punishment is punishable up to 7 years, ma'am.
What is the essence of allegation in FIR?
manufactured the document, Your Lordship, along in connivance with the bank official, Your Lordship. And has produced the document to the concerned authority to get an aid, Your Lordship.
Oh, good afternoon, Mr. By submitting forged bank documents
Yes, Your Lordship.
from Indian Overseas Bank International regarding appraisal of the projects and sanctioning a term of rupees,
3.10 crore.
no, 1.60 lakhs.
Yeah, he has obtained 1 first installment, Your Lordship. 1.55
No,
crore.
what
crore.
kind of a forged bank document?
Yes, Your Lordship.
What kind of a forged bank document?
There in, yes, it to be. Forced bank document, only in FIR is mentioned forced bank document, your lordship, I have to find out in the case diary, your lordship. Case diary, your lordship.
Forged documents, what forged documents were submitted?
Lordship, the document is not been annexed in the, your lordship, case diary. The document which alleged to have been forged, your lordship.
Yes, what do you say?
At this stage, your lordship. Your lordship, the forged document is not specifically mentioned even in the case diary that what exactly the documents were. No doubt the, your lordship, the documents, some documents has been seized from the accused, your lordship. And accused appeared before the IO by virtue of the notice under section 41A.
When?
Eight, 2023. 8th of August, your lordship. After your lordship filing, after filing of this bail application only.
Then there is no more apprehension.
No, now more apprehension, because
Why?
my lord, IO knows if this bail is rejected. So, they will arrest me, my lord.
Okay.
Because since it was, case was registered in July 22, my lord.
July,
22,
No,
my lord.
not July
Letter
20.
is from Turkish name, my lord.
No, July 23.
22 July 2023, my lord.
22 July 20, where?
Page 15, my lord.
Page 15, huh?
Yes, register and it's a case by number so and so, that is stamp is there on 22 July.
Oh,
22/7/2023.
22/7, it
Yes,
was
sir.
registered.
Yes, your lordship.
So that letter is dated 30 May, huh?
Yeah.
Okay.
No,
Oh, then,
8 at my lord. They are not arrested. And once telephone was called to the accused, then apprehending them, the accused approached before this court. Therefore, they issued someone under one notice under 41A, my lord. Then I comply with it.
when was that issued? 41,
On same day, 8, I think, my lord.
41A notice, no?
Notice.
41A.
41A, my lord. CRPC.
When was it issued?
On same day, my lord.
Same day
8,
means,
8, my lord.
okay, 22/7,
No.
8,
8.
your lordship.
8th August.
Yes.
Then,
Suppose I don't know why
then the moment you receive, you appear.
appeared and my statement was recorded.
Although he was not protected, your lordship, at that time.
Yes, although I know. Even if my arrest, my lord, I am cooperating, my lord.
Oh, this case was also moved on that day, huh?
Yes, ma'am.
It did.
Yes.
They moved PS.
Yes.
Yes, your lordship. Yes, your lordship, as per the case diary, your lordship, notice was issued on 31/7/2023, your lordship.
Hmm.
31/7/2023, your lordship.
You may have received it on 8th.
Yes,
Huh?
And giving him the date on eight.
Do you have
fixing-
the, do you have a
fix-
copy of the notice with you? 31/7/23, no?
Yes, your lordship, and fix a date on 8/8/2023. Was directed to appear on 8/8/2023, and in 8/8/23, his statement was recorded, your lordship. Complainant statement was not recorded yet, your lordship.
Complainant, who is the complainant?
Complainant is your lordship,
No,
Pankaj Kumar from Delhi is staying in Delhi because of the.
detailed statement was recorded
Yeah,
of.
his statement recorded.
Mr. R. Keter, counsel for the petitioner. And Mr. T. APP for the state. This is an application under section 438 of CRPC 1973 for granting pre-arrest bail to the petitioner, Sri Dari Raju, who apprehends arrest in connection with Durmuk PS case number 40/2023 under section 468, 471, 420, 120B 34 IPC. The aforesaid Durmuk PS case number 40/2023 was registered on 22/7/2023 on the basis of a request to lodge an FIR against the petitioner. Against the petitioner, written to the Superintendent of Police, Papumbari District, by one Pankaj Kumar, Director within bracket CEFPPC at page 16, 15 and 16. Alleging the petitioner, who is the promoter of MSD Raju Enterprise at IMG, within bracket D Raju Enterprise within bracket ST category at IMG, Durmuk, of availing the grants in aid for their project under the scheme for creation / expansion of food processing and preservation capacities within bracket CEFPPC bracket close of the Ministry of Food Processing Industries by submitting a fake bank documents. Full stop. Pursuant to the order of this court dated 8/8/2023, Mr. Ete Lanet APP has produced the case diary. Poster. On the basis on Mr. Ete Lanet APP on the basis of the case diary submits that a notice under section 41A of the CRPC was issued to the petitioner on 31/7/2023, pursuant to which the petitioner appeared before the IO investigation officer on 8/8/2023, on which date a detailed statement, only that statement of the petitioner in connection with the Jose Duemuk PS case number 40/2023 has been recorded. Full stop. Paragraph. Considering the nature of allegations made against the petitioner in the FIR as well as on perusal of the case diary produced by the learned APP, and also taking into account of the fact that the petitioner and that the petitioner had appeared before the IU on 8/8/2023 pursuant to a notice issued to him under section 41A of the CRPC, and the statement of the petitioner in connection with the Duemuk PS case number 40/2023 has been recorded on that day. I am of the view that the petitioner be granted the privilege of pre-arrest bail in connection with the Duemuk PS case number 40/2023 under section so and so. Accordingly, in the event the petitioner is arrested in connection with Duemuk PS case number 40/2023 under section so and so, he shall be released on furnishing a bail bond of rupees 50,000 with 2 sureties of like amount to the satisfaction of the arresting authority
IO.
on the following terms and conditions. Full stop. The petitioner shall render all cooperation in the investigation of the Duemuk PS case number so and so to the investigation of investigating officer, and shall appear before the investigating officer as and when called for in connection with the investigation of the Duemuk PS case number so and so. Full stop. Two. Till the statutory period for completion of the investigation of the case registered, comma, the petitioner shall not leave the jurisdiction of Papumpare or Duemuk.
Your Lordship, my lord, he is staying at Itanagar sector, there, Pakumpara would be.
Oh,
Your Lordship, maybe in general, Itanagar itself, Your Lordship.
huh?
Without prior permission of the IO, you cannot leave the jurisdiction of, yes, capital, Your Lordship, capital reason.
Capital complex.
Capital,
Duemuk does not come on the capital complex.
Your Lordship, maybe it's capital region only, Your Lordship. In general, Your Lordship, Itanagar itself.
Okay. Itanagar capital region includes Duemuk also.
Pakumpara, SP is there.
Different space.
So it will
Okay.
Pakumpara capital complex.
Duemuk and Duemuk circle and Itanagar
Capital. region.
capital region without the permission of the investigation
Yes,
officer.
yes.
That will be possible. And suitable application, distance disposal in terms of.
No hampering and tampering with the evidence, Your Lordship, that much, because it's a documentary evidence of there, Your Lordship.
Where will he tamper with the evidence? Okay, add that also. He shall not tamper with it.
Yes, that much.
And that is that witness also.
Oh,
Deeply obliged.
My lordship. Item 12 is for vacation of your own. Order dated 21/6/2023, passing CRP
Hmm.
27 of this. Annexure 1. Page 23. In my eye.
Of the IA,
Eye,
Annex 1,
page 23.
23.
Second last paragraph. Pending return of notice, the Parwana dated 1/6/2023 may not be given effect to Parwana. The
No.
respondent are at liberty to file appropriate application for modification, vacation of interim.
Hmm. This petition has been instructed against the Parva head governor. Soy means
It's a village in Leparada.
Sarsfield,
for settlement of land dispute between the petitioner and the. You are,
yes, private respondent. May lordship. In CRP, your lordship, they had basically challenged this complaint dated, lordship, 12/5/2023, page 30 of my item. They have challenged this complaint. Before the lordship, kindly see the annexure 3, page 27. This is the joint complaint. Filed by the.
IA,
Yes, in I.
page
Page
27.
27. 28 is the type of view.
Okay, yes.
This is your joint complaint. Lodged by the respondent.
Joint
Joint
by respondents.
respondent.
How many respondents?
Respondent, they have arranged only me, that is legal.
Okay.
Rest they had not made a part.
Uh,
In this
Le-
joint complaint, lordship, there is 3 issues has to be, issues lodged before the GB Nigam Pasar. Nigam village lordship. One is Yamerika. That is filed by the Lito Vasar. Second lordship, Hirerika, Leye Vasar and Marlu Vasar. Marlu Vasar, that is respondent. The third one is of Lichum lordship. By Lichum local witnesses. Kindly see lordship, page 30. This is complaint made by me.
No, just, what is page 28, you said?
28 is the joint complaint. lordship.
You are
In second lordship, Hirerika, Luya Vasar and Marlu Vasar. Luya. It should be Luya lordship. Wrongly written, type of. Luya Vasar. Is my lord.
Gohan, who is Gohan Basa?
When they are all my relatives. lordship.
Petitioner.
No.
Gohan Basa?
Respondent.
Mokkal.
Go ahead, lordship, they are not party before this court.
Okay. Mokal Basar is the petitioner.
Yes, there was 3 issues clubbed
You
together.
are Liga Basar.
Ligabasa. Three issues, lordship. They have been clubbed together. This is difficult.
Let us see the Parvana.
Yes. First lordship, page 33, lordship.
33.
Annexure 4 series.
Yes,
Initially on the joint complaint lordship, lodged before the AGB Nigam. AGB Nigam has forwarded the same to the GB president. lordship.
office of the
Kindly see lordship page 33.
appellate authority, inter-village customary, or
Lordship,
apex court,
kindly lordship see page 32. For a
apex
moment.
customary, huh?
Page 32.
32.
For a moment.
Yes. Yes,
I, Sri Todak Basar, AGV, in charge of Nigam village, received a joint complaint letter from the three persons, namely Lito Basar, Dr. Ligo Basar, and Sri Ligo Basar. I am hereby forwarding this joint complaint letter to you. Therefore, I am not an authorized person to issue a forwarder
what is the dispute about?
dispute lawsuit,
Land dispute
land dispute lawsuit.
between
Between,
you
be-
and, no, not only you said,
between me and Mokar Basar.
okay. Where the land is situated?
Land lordship, admittedly, it is now in Rege village.
Huh?
Earlier, Rege village.
Regi village.
Earlier, it was in
Which
Jigam.
district? Which district?
It's come Laparada lordship.
Laparada.
Earlier, it's come under the jurisdiction of Jigam village lordship. Rege has been recently in villagers of the Nigam and adjoining area have migrated and they shifted lordship at the present Rege village.
Land is under whose possession now?
They had cultivated lordship
Ah,
in this season. lordship.
you get it settled through court,
Yes.
huh? Otherwise, Lord, see, if you resort to this, not many things will come up. Customary court, inter-village customary, apex customary court.
Well, lordship. In our Galo custom, lordship, as per custom tradition,
Ah,
there is three type of cover lordship.
3 types of court.
Village level,
Ah,
Bango level,
Bango,
and Bogumboka.
Bogumboka.
In
Bango,
tradition,
Bango is what?
Bango intervillage.
Inter-village. And
Bogumboka
Bogumboka is district level.
district level.
It, huh? It will be,
It is custom lordship.
no, no,
The concept of this, customary practices of the Galawa method, trash method. In the custom practice method, there are 3 types of kebab of this method. First is kebab method, where method dispute of the same place is resolved by the kebab method. And method, there is another method, this is called method, Bango kebab. If the dispute method leads to inter-village method dispute, then method it is referred to the method Bango and kebab method under the customary practices method. And if it is method inter-district kebab method, then it is referred to method Bane kebab method. Bongo kebab method. This is the practices method. So what happened in this case method? Because the land, presently method, the admittedly lands to the Regi village method. Earlier though it was a Nigam village method. Now after method, the Regi village has been newly notified this method. So presently the land, disputed land falls under the Regi village method. That's why the Nigam head Gaura has referred to the method. There is a method, though it's an unregistered society, they have their own method. They have elected some president like that method. And so the president, he has sent the Gaura of the Nigam village has referred the matter to the president matter of the Gaura's matter. So the Gaura is because the dispute relates to matter between the 2 villages matter, Nigam and Regi matter. That's why matter the authority has constituted that matter available command matter. And their challenge is that matter there is no such provision under the law
for deciding the matter by the law of the well. Well, if that case, my lord, though they have not especially prayed that matter, which forum will be my lord appropriate forum matter for deciding the matter. To my respectful submission, my lord, if the land falls within the territory of the Regi village matter, disputed land, though we are from the Nigam village and they are from the Regi village matter, then under section 5 of the regulation matter, the village of every village has their own village authority matter. So if the territory falls within the matter, they are disputed matter, land falls within the territory, then let the village authority of the matter so you decide the matter. Huh? Or Regi matter.
So we'll hear the matter itself.
But I don't think that they will have the objection matter. Because,
Huh?
I have an objection. I want to get the matter redressed before the court, civil court, having competent jurisdiction. May I
it
submit?
is always open to him, man.
May I submit? Your Lordship, the case of the respondent,
No, just. See, we will be. I think so, but there is no any recognition of any particular customary forum by the court. I think we should be slow in this matter. Once we recognize, see, what you say, it may be correct, it may be the practice, but where are those written forms?
That I have one book, my lord, obtained from the Guwahati Research, Guwahati High Court Research Institute. There, these things were laid down in a book matter.
Book is written for on what basis?
Only for the
Go to,
historical purposes matter.
see, this law is creating, this will create problem for the court. If it is a problem for the court, that's not good for the society, people at large. For lawyers, it's a field day. It is that lawyer's paradise. You have 10 points to argue, he will have 20 points to argue in this case. He is now arguing particular to a customary practice of a particular community, particular tribe. We have how many tribes? Now each tribe will come saying, this is our practice, this is our practice. So we should be slow in recognizing this practice. But your land dispute will have to be resolved. We'll find ways and means. We'll hear the matter. Can't vacate this order. Because vacate this order means this adjudication will go. It will begin.
Yes, ma'am.
For
That's why my fair submission is that matter. If he says that matter, the president has no authority matter to refer the matter for vulnerable Deva matter, then on the basis of the present law in force matter, let the village authority of the matter decide the matter.
That's why I am saying this court cannot say, because village or who is village authority is itself a matter of debate.
yes, it has not been recognized by law.
Is not it? Who is the village authority? In other words, composition of the village authority has not been defined. According to you, who is the village authority? Gambura?
To me, Gambura matter.
Okay, if it is a Gambura, how many Gambura will decide? Which Gambura will decide? See, this is not. The lawyers should also be very careful in getting the law laid down by any of the courts. We are aware of these practical difficulties. We are proceeding with an extreme restraint. But if you make this kind of a submission, some court will lay down. So I think all of you should be careful.
Time to lay down some rules matter, laws matter. Because by the amendment matter, the customary code, definition of the customary code is that matter, includes matter, the village authority and the village council matter.
Now, if we say that first village authority, we may say that madam, the village authority consists of the head governor. Now, when it comes the madam, the village council madam. In the earlier practices madam, there were no Gavuras also. And after the advent of the British madam, Gavuras were appointed madam. But madam, in those village councils also, Gavuras were also there, but the madam, in the village councils, madam, elders of the villagers were requested to take part in that ballot because they know the customary practices matter. Now, under the new rules matter, a village authority can be appointed. The age of the village authority is 18 years matter. And qualification will last 10%. He may not know anything about the customary practices matter. These are the problems matter. In earlier practices matter, the village elders were appointed to be part of the matter.
It's a high time we move ahead. I have heard you. I have more questions than the submissions you have made. Second is what is customary law? Who knows customary law?
That's why, madam.
How will you decide that this land belongs to him or you? That village authority or customary court? Which law will the customary court apply? Customary court can try what? Case of a theft also? Theft also. What is the definition of theft under the customary law? Galo customary law? See, we are not here for any particular community. We are for the entire state. Now, you belong to a particular community, Galo. Okay. What is the definition of theft under Galo customary law?
The definition will be of the IPC matter. The punishment will be.
No, that definition of theft in the IPC was defined by Macaulay, Lord Macaulay. Isn't it? So this customary court of Arunachal Pradesh will interpret what the Lord Macaulay had drafted.
Yeah.
Number one, there are no end to the questions. Now, Singpho community will say, what is theft? We have one definition. We know not the IPC. And now at Basar, theft is committed by one non-APST. Which law will apply? Or some other tribe? Forget about non-APST. The theft is committed by Adi. Adi has a different sets of law. So which law will apply? So
it will be to my respect to jurisdiction only.
yes. See, these are the questions. It's not that easy. And in capital complex, we will hear the matter. Yes.
So,
Okay, good. Have you filed affidavit in opposition? Affidavit opposition required. Okay. And is there any other party?
No.
And all right. Like in the sometimes in the beginning of the Itanagar bench or something like that, village authority and Kewang has been held to be synonymous by the High Court. It was given such finding was recorded on the basis of arguments advanced by the council. So those judges coming from outside, you're not aware of it. Kewang is a village council, which Mr. Saikia has said it existed prior to 1945. So, and Kewang is unique to a particular community. It does not spread to other communities.
Yes.
So
Only Adigalu.
we should be careful. Legislature, they have made it. For them, it was necessity. They made it, but we should not. Even if you think for your client, huh, how to resolve it, it will be difficult. And there will be the rotation of litigations coming to the High Court, going back. Huh? All the parties are represented.
Yes. But they have the respondent number one, my lord.
Gambur
The
Welfare
Gambur
Society,
Welfare Yes, my lord.
they will have to be served. Okay, all right. Mr. Iva, learned counsel for the applicant, stroke respondent number 3, no? Respondent number 3. And Mr.
Titaba.
T. Tava, learned counsel for the opposite party, stroke revision petitioner. In the IA, no? We'll say listed up to 2 weeks.
One, after 1 week.
Huh?
After a week.
After a week, why after a week? These people will have to be served. See, you have taken steps, but notice is not yet served.
It will be after 2 weeks.
On the prayer council for the parties listed after 2 weeks, along with the revision petition, CRP 27 April 2020. What are you challenging? What are you challenging?
My challenging here in the case is that the FIR was filed on 1/9/2023. Then search was framed on, search sheet was submitted on 22/9/2023. The 31st/1/2023, search was framed. Now, after framing of the church, we came this petition under 482 of CRPC to watch the proceeding of the trial court, as well as the FIR, as well as the charge sheet. Now, the present status of the case is that it comes in the evidence stage. By this time,
You are challenging the framing of charge.
yeah, the order which was passed by the trial judge. Trial judge. Now, search was framed. Huh? 112. Page 112. Yes. Yeah, 112. And operative part is page 116. Here, and even a common person can understand that ENT doctor is not required to check the private part of any patient. To the most, he should refer the patient to a gynecologist if his patient had any kind of problem. Therefore, for the allegation level by the victim of accused putting finger and applying